Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome. This is Show Me the Market, and today our topic of discussion is going to take center stage at business and employment. Many people want to start a business, and if you want to start maybe different type of business, you need employees in your business in order to run your daily activity. With me in our studios today, I'm joined with a lawyer who is going to tell us more on the legal forms so that we can have in order to run our business. Is none other than Swaleh Yusuf. He's going to explain it more. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh.
How are you, Akili?
I'm alright, alhamdulillah.
Welcome back once again in our studios so that at least you can enlighten us about the matters to deal with business and employment.
Thank you for having me once again.
Moving straight to the point, maybe let us start by speaking some of the legal challenges that business face regarding when it comes to matters of employing people.
Okay, so there are a number of problems or challenges that come as a result of employment or employing people.
Yes.
Even before I begin, ignorance is no defense in a court of law. So it is very important for our viewers to be able to understand the same and to be able to familiarize themselves with the employment practices and laws. Now, the most common challenge that is faced is basically aspects of unlawful termination. Most of the times you find a situation whereby employers tend to find them in a situation whereby they are sued because of unlawful termination. And this is contributed mostly by the fact that most people do not understand the laws revolving around the procedures for you to arrive at terminating someone.
Contract.
Yes.
Yes.
So, for example, if someone has done a mistake, for example, there are so many requirements that are there, and there are so many processes that you have to follow as an employer to be able to successfully dismiss this particular person and not suffer consequences of suits in court.
Okay.
The other reason is aspects of sexual harassment in the workplace. There is a number of cases whereby sexual harassment is witnessed in a workplace. It can be between, it can be horizontal or diagonal. It can be between an employer and an employee. It can be between employees. There's also the aspect of discrimination in the workplace. You find a situation whereby an employee is discriminated on the basis of, for example, religion, discriminated on the basis of color, on the basis of sex, and all these usually have ramifications in law. You find a situation whereby the integrity or rather the reputation of a company is at stake as a result of such decisions. So it is very important for employers as well to be able to understand, even when employment policies of a company are applied, it is very important to be able to ensure that there is fair treatment of every other employee, irrespective of the differences in terms of religion and so forth.
Yes, you've tackled about the challenges business face regarding employment practices. Then maybe let us speak about the hiring when it comes to matters of hiring these employees. Before the challenges that you can face, you have to hire first. Maybe what are some of the considerations for a business person to hire someone to come and work for me in my company and everything, the legal business structures? Okay,
first of all, you need to be very considerate in terms of the communication out there.
Okay.
And when I talk about communication, of course, you will be able to do communication to the outside world that you're looking for example, an employee to fill in. And in that particular instance, that is where most of the employers as well go wrong, because it really matters in terms of the contents of that particular application. You need to be very careful in terms of how you structure that kind of communication. Because if you structure it in, for example, we've talked about discrimination. If you structure it in a way that will be able to contravene the aspect of discrimination for this instance. For example, if you say we are only employing people of this particular race, then you see that is a problem in the first instance.
But this happens when it comes to in this acting industry.
Yes.
But that there is a certain qualities they want, and
Yes.
they'll be like, I need an Indian young boy.
Yes.
Yes.
So that
that's
is a disaster even in the beginning.
Okay.
It is a disaster in the beginning. If someone takes up the issue and, for example, files a matter in court on the basis of discrimination, the company will have adverse ramifications. Yes, because of damages and compensation in court. So even from the beginning, in terms of the communication that you put out, so that people can be able to apply, is very important. You need to be able to abide by such conditions. You have to be fair in terms of the people that you recruit. Once you've been able to shortlist the tenable employees, although it's usually internal in terms of choosing mechanism, that's okay. But subsequently, after deciding who you want to employ, it is very important to be able to understand that the law requires that you do an employment contract with that particular person, a contract of service.
Okay.
And it is the requirement under law that if someone is employed for more than 3 months, it is a requirement that that particular person should be able to have a contract of service that is in writing, not orally, but in writing. In the employment contract, and actually this is the mother document that establishes the relationship between the employer and the employee. The employer has to get it right in terms of the terms and conditions of employment. In terms of remuneration, it should be very clear. In terms of dispute mechanism, for example, if there's an issue, how do you address the issue? It is very clear. It should be very clear. Otherwise, you tend to find yourself in a situation whereby it is very difficult for you to pull out, for example, of that contract. Somebody will go and sue you. So attention and detail should be able to be put in the contract of service. Now, there are usually mechanisms to be able to protect an employer, for example. In the employment contract, you can be able to define, for example, a probation period. Because you've employed someone, you have to assess the person, for example. Yes. So it is important in that contract of service, for example, to be able to have a clause talking about a probation period. And according to the law,
it is a must.
It is not a must to have a probation period.
Or depending with the person that you are hiring?
Yes. Although as a matter of procedure, as a matter of practice, it's usually important before employing someone on permanent and pensionable terms to be able to have a probation period, because the probation period gives you latitude in terms of an employer, either to continue with that contract of service or to be able to opt out of that particular employment contract. And the repercussions in terms of the law is not that much. You have some form of flexibility.
I wanted to ask, it should take at least how long for me to be in a probation?
Okay. So according to the Employment Act of Kenya, an employer can only stretch to a probation period of not more than 6 months. So you cannot be able to, for example, give someone a probation period of 8 months or 1 year. That is against the law. Yes. So in the context of now this probation, I was saying it is important so that you can be able to assess somebody. There's usually a clause that you can be able to input in this contract of service. And the clause is, for example, on the aspect of performance. As an employer, what is important to you and the reason why you're bringing someone on board as an employee is the aspect of performance, because that will be able to generate income for the company. So it is usually very important as well to be able to have a clause to do with performance of work. What are the repercussions if this particular person is not up to the task? What rights and responsibilities would you have?
I think most of the CEOs or the business people, they focus maybe on that much, despite speaking about, okay, if this person delivers, maybe what are some of the goodies that this person will bag while going home? I think they should also concentrate on that much, comparing with when this person maybe fails to do these, these are the consequences that this person is going to face.
I was actually going to the next clause, and that is the next clause of benefits. If the aspect of course, on the perspective of the employer will be insisting on the aspect of performance. But in the context of now, this situation whereby the employee has been employed, this employee has been able to be successful in terms of complying with the performance standards that were raised, then the issue of benefits comes in. And I want you to understand that it is very important when you're having this discussion. Remember, this is a contract of service. It's a contract. And contract is a meeting of the minds, which means that both parties are equal before the law. Both parties have a right to be able to define or dictate terms. Although in the normal context, most of the times, especially if you're looking for employment,
it is the company.
Yes, it is the company that has the upper hand.
Yes.
But the way the law is established, the position is such that the employer and the employee should be in the same pedestal in terms of especially defining terms and conditions of this particular contract of service.
Okay.
I have seen in very many situations whereby employees, because they know, some of the employees, because they know their rights, they usually dictate the terms and conditions of the contract, in the sense that a contract will be offered to you.
Yes.
You have a right to be able to review it. I'm sure there will be terms and conditions that do not favor you. And in the context of the market, they are also not consistent with the standard market prices. You can be able to negotiate on the same.
Speaking about contract, reviewing your contract,
yes.
Maybe it should take how long for you as a person who is being employed in a company to review your contract? Because you find most of the time, you went there, you've been given the contract, you're desperate, you want to work, all you want to do is just kupitia haraka, then you put your signature and you're done with it.
Yes.
Then it should take you how long? Can you go with the contract at home? Can you take it to your lawyer so that at least can help you in terms of maybe expounding more and explaining more about the contract, what the contract entails?
Like I had indicated, this is a meeting of the minds, and you're on the same pedestal.
Yes.
Of course, it is your right to be able to go out there to seek legal service. Or consultation in terms of your contract and get advice on what aspects can be improved and all that. But unfortunately, by virtue of the nature, there is the law and there is the practice.
Yes.
Unfortunately, you find a situations whereby as much as the law is rosy, as much as the law has strived to be able to protect the employee, you will find scenarios whereby an employer has given you a contract of service, has not given you an opportunity to even be able to go through it. You're only required to be able to sign.
You just sign.
Yes, to be able to sign, and that's it. And in other unfortunate circumstances, but unfortunately common, you find a situation whereby you're not even given a copy of the contract of service, when the law is very clear that an employee is entitled to a copy of the contract of employment. In best practices, in terms of time frames for renewal of contracts, we usually have periodical contract of services whereby, for example, considering the change of market trends and all that, maybe, for example, within a period of 2 years or 3 years, the contract can be reviewed. But most of the times you find a situation whereby this contract of services that you've been offered are very silent on the aspect of reviewing.
Okay.
Yes.
Okay. I think at this point, we're going to take a short break. When we get right back, we want to speak about some of the companies and some of the complaints that we get, people working in a company, and you as a person who is starting a company, on how at least you can save yourself from this hole, which most of people, they get into it. I'm taking a short break. When we get right back, I'm going to tell you more about it. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back. This is Horizon TV and the show is Show Me the Market. Our topic of discussion today is business and employment. Before we took our short break, we were discussing about hiring new employees, some of the considerations that you as a person or a business person whom you want to employ someone, the terms and conditions that you should have in order for that person to work for you in a good way and a successful way. With me in studios today is Yusuf Swaleh, who is telling us more, Bwana Wakili, is telling us more about these tips so that you as an employee, you as an employer, you can understand the legal forms directly. Assalamu alaikum once again.
Wa alaikum salam.
Welcome back.
Thank you.
Earlier we were speaking about the hiring employees, maybe the terms that we should have. In order for you to employ these people, now you should have a company first. If not a company, you should have maybe a business so that at least you can hire. So maybe the compliances with employees' laws and regulation to avoid maybe legal issues, because you find legal issues erupt each and every time. For instance, maybe someone wants to resign from the work. Maybe what are the legal steps that I have to take in order for me to move away from this company? Yes.
We will begin with the conversation that we had.
Yes.
The most important bit, the mother of everything in terms of defining relationships, is that ensure as an employer, you give an employment contract, a contract of service to the employee, because that particular contract of service is what will basically define the relationship. The relationship in terms of benefits, the relationship in terms of, for example, leave days, the benefits in terms of dispute resolution if there's an issue. It will give benefits in terms of maternity leave, for example. So many
even
aspects
leave,
of
normal
it.
leave.
Yes, even normal leave.
Yes.
So the contract of service is the primary document that will be able to define the relationships.
Okay.
And remember, industries differ from each other. There are salient aspects of, for example, a certain industry that will not apply to another industry. And this is a perfect opportunity for an employer to be able to input, for example, clauses that are applicable to that nature of that business.
And speaking about leave, there are some companies that they tell people, we don't count your Saturdays and Sundays. Do Saturdays and Sunday count inside a leave?
You will always fall back for such a certain question like that one. You'll always fall back to the employment law in terms of leave. So in this instance, if you're talking about leave days, the Employment Act is very clear in terms of the leave days that are applicable to an employee. And it is at least 21 days in one calendar year. But that particular provision is not exhaustive in the sense that as an employer, and because this is a meeting of the mind, you can be able to decide to have a contract whereby leave is more than 21 days. But the minimum according to law is 21 days. You can have 30 days, that's okay. It's a contract of service, so long as the same is not inconsistent with the law.
Okay.
Minimum 21 days, yes.
We've mentioned about the companies, and maybe let us speak about, me as a company, what are some of the steps that I can take in order for me to cover up or to clear these misunderstandings and the conflicts that comes in?
Have a contract of service, have something called an HR policy. An HR policy in terms of discrimination, an HR policy in terms of sexual harassment, HR policy in terms of discipline, a disciplinary process, HR policy in terms of termination of employment, because termination is in different manners. You have, for example, summary dismissal. Summary dismissal would happen in a situation whereby someone has done something that is fundamentally a breach of the terms and conditions of service. For example, if someone comes to work intoxicated, that is a very good ground for an employer to summarily dismiss an employee. There are also other aspects of redundancy, but we'll be able to go into the details. Redundancy would happen in a situation whereby there are different market trends, they have adversely affected the company, and the company is forced to be able to restructure. Yes. Also, strive to be able to seek legal consultancy from, for example, HR experts, from lawyers, also liaise with basically labor office. According to the law, there is a labor office that actually employees can be able to go when they have a complaint. Yes, so it is very important to be able to liaise with this kind of offices so that even these disputes can be able to be handled in the basic stage and you do not have to go to court.
Okay, there is a question which came in about mentioning the 21 working days in a company.
Yes.
Does it apply to these 21 days?
Yes.
Does it get back to your weekly or maybe daily? Saturdays and Sunday, maybe try to explain it more. When you count your leave off days, do you have to count the Saturdays and Sunday in it on these 21 working days?
It will be dependent with the contract of service. If Saturday and Sunday is construed from your contract of service as a working day, then that 21 day will be within the working day.
Okay.
So it is dependent on how the contract of service has been structured. If it is special in the sense that Saturday and Sunday is a working day, then unfortunately, yes, it will be able to count. But assuming the contract of service has referred to the employment law as the source, or rather the guidance, then Saturday and Sunday in the context of the Employment Act will not be able to be either Saturday or Sunday. It will be Monday to Friday. I hope I've been able to clarify the issue.
Yes, at least you've clarified it, and it depends with the laws and regulations of your company.
Yes.
Okay.
It depends with that particular contract,
and the
that
contract
you signed. Yes.
So that everything, the center stage, it is the contract that you sign.
Yes.
So it is not advisable to do what is not in your contract.
Yes.
Okay, sir.
Yes. Although there are other situations whereby a contract of service was filed, or rather was signed by both the employer and the employee, but the terms and conditions that are in the employment contract is contrary to the law. Okay. And if that is the situation and people end up in court, the court will not be able to construe or interpret that contract of service according to the contract of service, but it will be able to fall back to the law. Remote work, in very simple terms, is basically working from home. And commonly it's referred to WFH to mean working from home. And that's the reason why I'm saying this phenomena came into practice, so to speak, when the COVID scourge hit us, because it was very difficult to be able to go to the workplace, and it really got us in a situation whereby we had not harmonized our laws to be able to provide, so to speak, structures for such kind of arrangement. Okay. So it has its positives and it also has its negatives. But in the context, in terms of the challenges that are there, for example, what will be the position in terms of right to housing? Does a person working from home, is that person entitled to housing? The other challenge will be, there are usually expenses that will be able to accrue to an employee if you're working from home. You require a gadget, okay? Is the employer providing you with a gadget? There's the issue of the internet. Is the employer providing you
electricity
with internet, electricity? Is the employer providing you with the same? Mobile devices. We can talk about software. You need to work with a certain software and all those other things. So unfortunately, in the Employment Act, like I was saying, it could not, or it did not anticipate such a situation. So in our laws, there are, I'm trying to look for a simple word. In law, it's called lacuna. There is a gap because our laws has not been able to address such aspects. Because if you look at the Employment Act, it only talks about, in the employment contract, you're supposed to dictate benefits. You're also supposed to have a formula within which to be able to determine remuneration of an employee. And here we are talking about additional aspects. We do not even talk about an ergonomic chair. If you're sitting at home, for example, will the employer provide you with the seat?
Because you need to be comfortable.
So that you can be able to work.
To deliver the work.
So our laws, unfortunately, have not been able to address that particular aspect. And you will find a situation whereby we talked about the periodical reviewing of agreements. And I told you that in the context of our practice, most of the times you'll find a situation whereby you have a contract of employment that has not given an opportunity of reviewing a contract of service. So here you are in a situation whereby COVID has happened, you've been forced to work from home. In your employment contract, it does not define these other extra expenses that you're incurring. And of course, for an employer, he or she will be able to stick with the employment contract. However, we as a country belong to ILO. ILO is an international organization and usually defines best practices in terms of industry, in terms of employment and all that. There is a case in Switzerland that just happened the other day whereby someone was working from home In the contract, there was no definition in terms of these are the extra costs that you are talking about. But the court was able to interpret and indicated that that employee is entitled to housing. Actually, the employer is supposed to pay half, to cater for half of the employer's rent. Because you see, for example, you'll have to sacrifice one room to be an office, for example.
Allowance.
Yes.
They get.
Yes. So in that particular case, the court indicated that the employer was required to be able to pay half of the rent of the employee. It also indicated that the employee is entitled to those expenses that you talk about.
Okay.
Yes.
Maybe moving forward to maybe our question, because also time is not on our side.
Yes.
Maybe what can a business protect? How can a business protect themselves from a potential lawsuits related to discrimination or harassment in the workplace?
Okay. First and foremost, you need to have an anti-discrimination policy in place. And the law is very clear in terms of these policies. These policies have to be explained to the employees. They need to understand what this anti-discrimination policy is all about. So you need to do a lot of training.
Yes.
Number two, you need to post it in a very conspicuous place. Yes, so that it is known there is a policy in respect to this
notice board.
Yes, there is a policy for this particular company in terms of anti-discrimination.
Okay.
Consult widely. I see most companies usually have a legal department, or within the HR department, they have someone with a legal background, so that that particular person or that particular department can be able to guide you on harmonizations of the laws or acting within the confines of the law. Also, be part and parcel of Federation of Kenya, for example, employers, because through such kind of organizations, you're able to get information and knowledge in terms of treating employees, in terms of complying with the law, in terms of even adding a voice towards improvement of an environment, a working environment. Yes. And also have periodical audits of your policies. Because you see, the world is evolving. You might have a policy today, but there are other aspects that will be able to change. So also have this tendency of auditing your own policies. Do they, for example, meet the standards of the Constitution? Do they meet the standards of employment law in Kenya and all that? Yes.
Thank you so much. And you know, maybe there are some companies which they go to an extent of whereby not paying their employees for more than even a year, for more than even 6 months. Maybe you as an employee to this company, what are some of the legal action that you can take?
Number one, you can be able to register your complaint or dissatisfaction with the county labor offices. Can be able to raise a complaint there. Number two, you have a right to be able to go to the Employment and Labor Relations Court. There is a department, or rather there is a court with the stature of a high court that is called the Employment and Labor Relations Court. That court was only established for purposes of handling employment issues. We also have labor organizations. These are the forums that you can be able to raise your concerns with. Yes, you have unions. Yes.
The chances of you maybe to win this case, is how you can give it how many percent?
Fortunate for employees,
Yes.
the way the employment, from my perspective,
Yes.
the way the employment laws are structured in Kenya are structured in a certain manner that is favorable and protective of employees. So the chances of an employee to be able to be successful in a court of law is very high as compared to the employee.
That's a good one. Before we clear this, there is a very important question here on how to a startup of maybe regarding employment's contract in a company policies. Maybe what are some of the legal advice you would like to advise people, you as an advocate, when it comes to matters of setting up an employee contract? What are some of the key issues you should put in so that all of these pros and cons should not come into your docket?
Okay, number one, and without unnecessary format, I'm looking at the most important aspects. You have to be very careful, and this has to form part of any contract of service, whether it is simple or complicated. You have to have a resolution mechanism in a situation whereby there is a dispute or a complaint against an employee. Most of the times, you will find a situation whereby an employer or an employee, has gone to court on aspect of unlawful termination. And unfortunately, according to the law, if you terminate the services of an employee, from the perspective, especially if it is summary dismissal, from the perspective of an employer, you have to prove to a court of law that the termination was valid, that the termination was fair. The reasons for termination was fair.
Okay.
And in a court of law, it's quite very difficult. So if you have a mechanism, a resolution mechanism in terms of disputes, whereby this person is subjected to right to fair hearing, goes through a process, is heard, there are investigations that are done,
Okay.
there are warning letters and all those other things, you protect the company from litigation.
You cannot just wake up today and
Yeah.
say you're fired.
Yes. Even in instances whereby the law allows you, for example, I'm talking about summary dismissal,
Yes.
whereby you are allowed to be able to do. My advice will be follow the structures in terms of listening and resolution of such mechanism, because without that, it is very easy. Like I told you, in an employment and labor relations court, and given the law that is there for employment, it tends to favor the employee. So you find yourself from a very difficult position as an employer.
Yes.
Yes, to be able to explain. So you would rather, even in a situation whereby an issue is clear-cut, just follow the process in terms of affording this person a right to fair trial.
To be in the safer side.
To be on the safer
I think
side.
at that juncture, we don't have much to add, Bwana Wakili. And thank you so much for your time for coming today and also explaining us more and expounding on business and employment. And at this point, what I can tell you is that, in Kiswahili, they say, sheria msumeno na inakata mbele na nyuma. So if you don't follow the rules, the law and regulation of a country, of a company, don't expect to have maybe a rosy or a good company that can benefit you, that can give you fruits that you've been expecting since you started your business. At this point, I don't have much to tell you or to add on this. At this point, we are wrapping up for season 4 and see you for the next season. My name is AbdulRahman Gaddafi Yassin, and this is Show Me the Market.